firstly, apologies, I've come through quite late. Poppy has been working miracles trying to get things sorted here, but unfortunately, even by Parliament standards, the wireless and the Wi-Fi connectivity has been pretty shocking today. So I'm sorry I'm a bit late, but I'm ready to start. Charlie, can I just issue an apology in advance? There are going to be some votes here, which is why I'm here and not there, because I haven't been slipped, unfortunately. So therefore, once Parliament starts voting, I'm going to have to hand over to you.
Got it. Thanks, Bob.
You're nodding. And if you could shout yes or nodding every so often, I'll just crack on. Do you want me to start and introduce? Okay. I think we have some serious legal problems in our country, and we have certainly problems with non-conventional forms of conflict and this stuff known as lawfare, which is about the use of law, not necessarily for public good or for the settlement of legal disputes, but as a form of power projection. Whether it's attacking countries or whether it's trying to bankrupt individuals, we see Putin's oligarchs using lawfare in this country and in a way that their critics would argue is trying to silence freedom of speech, trying to silence a free press, etc., and not necessarily to settle more narrow disputes. I think this is something that Parliament should be taking seriously. It's something that I take very seriously because of my interest in Russian hybrid war and forms of hybrid war. I know that there are some great proposals, which I hope we're going to talk about in this session. And although I've got the proposals here, because I'm not a lawyer, I'm hoping that our expert panel is going to enlighten me and enlighten other folks there at your excellently named anti-SLAPP conference. And again, apologies, I'm not there in person. And guys, I'm now going to introduce you all. And are you then, if I understand, Charlie, we're going to have a brief introduction to sort of 2 to 3, 4 minutes from everybody just to talk about their area of expertise. Either we're going to be taking questions from me as the sort of interested but non-expert audience, or we're going to take questions from the floor. Is that correct? Yeah,
that sounds good, Bob. I probably have to take a few more minutes on the introduction just of the measures, but yeah, roughly fine.
As you see fit. So I'm just going to introduce myself. My name is Bob Seeley, Member of Parliament for the Isle of Wight, and I sit on the Foreign Affairs Committee, and I have an interest in hybrid warfare and forms of sort of non-traditional threat. So Charlie Holt, do you want to, I'm going to hand over to you, Charlie, and then should we go through everyone's on the panel to introduce yourself and the key points that you think need to be raised?
Thank you very much, Bob. My name's Charlie Holt. I am UK Campaigns Advisor for English Pen. I think we're all probably feeling a bit emotionally fragile from the last very, very powerful session, but there's no better way to impose a stiff upper lip than for a relentless focus on the law, and that's what our role is going to be this afternoon. I have both the pleasure and the unenviable task of going through some of the mechanics of our proposal. I will try to be as quick as possible. It might take a bit more time, but I will try and get there. Just very quickly, by way of background, the working group on SLAPPs has been around since the beginning of the year. One of the first things we did was to put together a policy paper, which I've got here and anyone can look at afterwards, to establish a common advocacy position, a common position on what it is that we are calling for and who it is that we are calling on to act. To do this, we, as well as assessing the situation in the UK, we reviewed the measures that had been introduced or proposed around the world. So that includes the 32 anti-SLAPP laws that exist on state level in the USA, the 3 provincial Canadian anti-SLAPP laws, the Australian anti-SLAPP laws, measures that have been proposed in Europe, including most notably the European Union Model Directive proposed by CASE. We identified through this process 5 principles which any type of anti-SLAPP measure needs to advance. The first is that SLAPPs need to be dealt with and disposed of as quickly as possible in court. SLAPPs obviously take advantage of the litigation process, and that process needs to be as short as possible as a result to minimize the potential for abuse. Secondly, costs for SLAPP targets need to be kept to an absolute minimum, thereby minimizing the financial threat of SLAPPs. Thirdly, the costs for SLAPP litigants needs to be sufficiently high to deter SLAPPs, and that obviously involves some form of sanctions. The fourth principle is that laws implicating speech need to be narrowly drafted to avoid the potential for abuse. And lastly, the use of SLAPPs or legal intimidation needs to be delegitimized as a means of responding to criticism. Then the next step for us in the working group was to work out how these principles translate in a UK context. Now, obviously, that might involve, to some extent, reforming existing laws, such as, for example, defamation. There's obviously no magic bullet when it comes to changing the culture around SLAPPs, but a good place to start is by reforming some of the professional ethics that govern the conduct of lawyers. We recognized, however, that the first three principles, that is the early dismissal, protective measures for defendants, and sanctions for plaintiffs, needed legislative reform. A lot has been said, for example, during this conference about the importance of the Defamation Act of 2013, and it was important, but it's important to make a distinction about the difference between substantive law and procedural law. However robust the legal defenses that are made available to journalists, they are of little use in the context of SLAPPs if they only work to dispose of a case at trial. So having identified the need for new procedural protections, we convened a legal roundtable to discuss exactly what a UK anti-SLAPP law would look like. And we were very fortunate to have my co-panelists here today at those roundtables. In this conference, we addressed three questions, and I think we've got slides to help guide this. Is this working, the slide? Yeah, brilliant. So the first question was, how much of this is just about judicial education? How much of it is due to a lack of sensitivity about the use of SLAPPs and the way that existing mechanisms can be applied in the context of these tactics? Secondly, to what extent can we address the issue by modifying rules of civil procedure? In the context of England and Wales, this question is particularly significant given the civil procedure rules. The CPRC, the Civil Procedure Rules Committee, cannot make new law, but it does have a mandate to ensure the civil justice system is accessible, fair, and efficient. And Nicola Solomon earlier today, if you were in that panel, made this point brilliantly, and she's emphasized the overriding objective of the CPR of enabling the court to deal with cases justly and at proportionate cost. Finally, what is left over? What would a UK anti-SLAPP law look like? What are the remaining bits that need to be covered? So the proposal document we have, and I've got it here, and we will be launching it after this session, it's split into three parts. I think the next slide we can see this. And just very quickly, I'm going to go through these recommendations. I don't think you can read these on screen, but I'll explain what they are. So first of all, in the context of judicial guidance, we found there was a need for both new or amended practice directions and training, specifically in relation to two things. First of all, the use of security for costs to test the seriousness of a claim. But that applies in cases where a motion to strike is not possible. The second thing here is the motion to strike, and that's important. Motion to strike should be used. It can be used to filter out abusive claims. And much of the case law on the definition of abuse of process includes the improper purpose, the improper use of civil proceedings. And that, of course, includes the improper use to silence public watchdogs. So that's something which very much needs to be elaborated on and drawn out. In the context of civil procedure rules, we've called on the CPR committee to assess how the CPR can be amended to address SLAPPs. And again, there's a focus on three things here. One is summary judgment, which at present is clearly inadequate to deal with SLAPPs. Secondly is cost orders, which allow the judge to depart from the default loser pays principle, where the claim is intended to have or will have the impact of chilling further acts of public participation, or rather that is the way we think it should be amended. And lastly, a potential pre-action protocol. I think this is something Sophie will go into here, but it's important to set out the court's expectations about pre-action conduct. We've covered this during this conference. It includes mediation, it includes the use of small claims courts, and potentially includes the right to reply process that we've been speaking so much about. All of this provides the context to the anti-SLAPP law itself. So what exactly is that trying to achieve? Well, first of all, an affirmative right to public participation, reinforcing the application of Articles 10 and 11 of the European Convention on Human Rights, in the context of civil lawsuits, and defining the scope of the law. Secondly, a filter mechanism, that is a new means of summary disposal that would create a higher threshold that has to be met for claims which are targeting acts of public participation. This would also involve the suspension of proceedings to ensure that, for example, cost-intensive measures such as the disclosure process is not used to harass a defendant. Thirdly, and I think this is crucial, sanctions. All costs should be automatically borne by the plaintiff where the case is found to be a SLAPP. But furthermore, exemplary damages should be made available for cases where the claimant has exhibited a particularly egregious conduct. Linked to that is this civil restraint orders. Courts should be empowered to issue civil restraint orders against repeat offenders, those who use SLAPPs more than once. There already exists a registry on the MOJ of vexatious litigants. This should be extended to SLAPP litigants so that that goal of delegitimizing SLAPPs, naming and shaming, is advanced through these measures. So that's it. I'm going to shut up. If you think all of this is utter rubbish, and we really would like to hear from you. If you've got anything you would like to add to this, to suggest this, please do get in touch. We will launch a public consultation after this, and we would love to hear from you. That will be open till the end of December. And Bob, I see your hand, and I'm sorry for going on as long as I have.
No, I'm so glad you did, actually, and I'm so glad you talked for as long as you did. And just before we bring in Sandhiya, can I just ask you a couple of sort of almost yes? Are you sure we need new laws? To what extent is changing culture alone enough? The human rights stuff, surely that's better in UK law. And do we have good examples from other states, which you talked about early on?
Mm-hmm. Okay, so I didn't hear all of that. You broke up a bit, but I'll try and answer them. I think the first question was about new laws rather than amending existing ones. Yes.
Do we need a new law? Okay.
Yeah, so the first one is we will, just to elaborate on why. So for example, you can amend something like defamation law. You can even, the Defamation Act of 1996 did have a disposal mechanism, but as we've heard from this conference, this extends beyond defamation to all sorts of laws. We could fix all of the laws we know are problematic and new mechanisms which would emerge that would then be weaponized by SLAPP litigants. So we need to preempt that, and it needs to be all-encompassing, and that's why we need a new law. In terms of the human rights, I think this is quite a simple one. I'm sorry for making that clear. When I talk about the European Convention on Human Rights, obviously I then talk about the Human Rights Act and about the way that that should be interpreted in the context of civil law. And again, having that affirmative right helps aid the interpretation in a way which I think is appropriate.
Thank you very much indeed, Charlie. Charlie, can we now bring in Sandhiya, because she's sitting next to you, to discuss sort of her thoughts, not only on, in regards to her role on index and censorship, but also taking the arguments that you've very eloquently outlined forward. Sandhiya, over to you.
Thanks, Bob and Charlie. I'm Sandhiya Sophie Argent. I'm a freelance media lawyer. So I've advised on everything from news and current affairs to even dramas and entertainment shows. So my my sort of whole role is working with journalists and producers, navigating around all of the laws that we've spoken about, whether that's defamation, privacy, data protection, and also sort of Ofcom regulations as well, to really help journalists and producers make interesting, compelling public interest content, not just for themselves, but actually for us. And I think that's something that we always have to bear in mind when we're looking at Article 10 is also our rights to sort of receive that very important information. I think as sort of Charlie was pointing out, I mean, I come to this as mainly as an in-house lawyer, although I've just gone freelance and very much understand how exposing that can be. But in-house, if you are a journalist or a program maker and you've ever had to sort of work with a lawyer, the first reaction might be, to possibly roll your eyes. But hopefully, if it's someone like me and hopefully Rupert and other people, really our aim is to try and get you to make that content in a way that's legal and robust. And I think a lot of my frustration working in-house has been part of that process, which is the right to reply process, is an integral part of it. You know, as journalists or people making content, you are, and rightly so, you know, judged on your ability and your evidence and work, and how you've, you know, responded to the subject of those allegations. For me, a frustration comes that right to reply process is actually undermined and becomes a stalking ground, really, for litigation, for threats. And the point of the right to reply process in pre-publication is to demonstrate responsible journalism. And a lot goes into measuring journalists or publishers and how responsibly, and media organisations, how responsibly they've acted in that period. But where is the focus on claimants or potential claimants who actually abuse the process, who use it, as I say, to threaten, not to engage with your letters and your claims that you've meticulously researched? You as the lawyer and the journalist are very satisfied that you have a robust, defendable piece of journalism and content, only to be met by intimidating sort of tactics. And for that reason, I think there should be sort of specific ring fencing around that right to reply process, which means that you cannot, as a claimant, use it to threaten baseless threats and to use it to intimidate and not to engage with the questions that are being asked. So as you can probably tell, I'm very passionate about that, because I've had many times where even the most robust of journalists has often broken down, because, you know, we're talking about their reputations here and their livelihoods that are on the line. And so I think it's incredibly important that as any measures, particularly in the pre-action space, really safeguard that right to reply process. I think that's me.
Sandhiya, can I come in and ask you a quick question on that?
Yeah.
Thank you so much indeed. Again, that was really fascinating. The people I see using this threat are foreign oligarchs doing it as a form of almost state-level intimidation. But clearly, you're going to see a lot more people trying to use anti-SLAPP legislation to try to intimidate. So who are the people who are doing this, you know, Putin oligarchs aside?
Well, there are also big companies, big corporations that have the money, that have the resource, that have the time to engage expensive lawyers to fight their claims. So it's not. There are many of those sort of actors that you've mentioned, but big corporations are also a big part of this that I've seen in my work. And you know, some of the, I can't obviously for obvious reasons talk about specifics, but some of the investigative work that I've helped with are, you know, showcasing big companies that are engaged in human rights or have some connection with human rights abuses. And you can bet your dollar or your pound or whatever that you're going to get a very aggressive letter back from those corporations, almost as a matter of course, really, if you step anywhere near that.
It seems to be an incredibly important point to make, because clearly there are significant human rights abuses being conducted throughout the world. So thank you for that. Rupert, you're next on the panel. Can I ask you to A, introduce yourself, and B, to outline what you'd like to say, please? Thank you so much.
Thanks, Bob. I'm Rupert Cowper-Coles. I'm a partner at RPC, and I'm in the media defence team, where we represent media organisations, broadcasters, newspapers, freelance journalists, NGOs. So I wanted to make a few comments on the proposals that the working group have put forward, and from the perspective of somebody who is often tasked with taking over a piece of litigation, and often what we describe as SLAPP litigation when it actually goes into the courts. Taking a step back, I think all these proposals are very desperately needed. It's very. Last night we had Claire Rucastle-Brown talking about her experience, where the leader of a foreign political party in Malaysia, who wasn't even named in an article, brought a legal action to in our courts over pretty low online publication here, over an article discussing the 1MDB scandal. Now, a politician who wasn't even named, the article discussed foreign politics and corrupt payment flows, and our courts were dragging Claire all the way to a high court trial that the lawyers on the other side's costs were going to be well over £1 million. And no other profession I can think of, other than investigative journalist, would you, as a matter of course, face the risk of being sued regularly just for doing your job, have your house on the line, and be dragged through a process like that. Just taking a step back, there's got to be something wrong where litigation can be used by the very, very wealthy people who, globally wealthy people who all have English lawyers and have access to these reputation management departments to, as a matter of course, intimidate and often sue investigative journalists for producing public interest journalism. All the presentations today have really rung home, and just at the coalface when you're fighting litigation, doing Claire's case and the number of other SLAPP cases that come across our desks more recently, you can open the practitioner's texts which talk about how to strike out a claim at the moment, and there's nothing in the practitioner's text on contempt or abuse of process that says the word SLAPP at the moment. Simply no recognition. And when Claire was being, her witnesses were being intimidated, when documents we were sending to the other side were appearing on trolls' websites, harassing her and photoshopping her, and when she was getting death threats from people who were being passed documents by the other side. We looked at abuse of process, striking out the claim as an abusive process, and we've considered these applications in a number of cases. But bringing an application at the moment there's very little case law. It's highly risky. Your costs could easily be £50,000 in bringing one of these applications. The other side's costs will almost inevitably be double. So if you lose that application in this untested area of law, you're £150,000 down. I think there's going to be a case where someone should test these principles and try and push the law forward. And you've got to remember that our judges can be activists, and when they see injustice, our law does evolve and develop in the UK. And the Reynolds public interest defence was created by judges, moving the law forward. Having said that, I think these proposals, I think this is a pretty urgent situation. I don't think we need to sit here hoping for the right case, hoping for someone who's willing to throw a few £100,000 to take a gamble that they've got to get the right judge, they get the wins behind them, and they can move precedent on. Judicial guidance, whether it's practice directions or possibly guidance from the master of the rolls, could play a really important role. About 10 years ago, we had the super injunction spring and the scandal of basically court processes and court orders being made which couldn't be reported at all. The orders themselves made them unreportable, and it was the master of the rolls interim guidance on the interim non-disclosure orders, super injunctions, which effectively has solved that problem. He's implemented transparency, reporting on the number of injunctions, how they should operate, and so that judicial guidance has vastly reduced the number of abusive super injunctions. And when interim privacy injunctions are brought, they're generally warranted. It's normally in cases where there's blackmail or some other proper reason for maintaining someone's privacy. So I think judicial guidance and practice directions. Security for costs is an important, very important lever, and at the moment it's simply not fit for purpose for getting rid of claims. It's very, very hard to get security for costs against an individual, even if they're based abroad. And we need to change in the rules so that changes. I do remember my fellow partner, Keith Matheson, I might not be quoting this correctly, but he had a case about 10 years ago involving a Sudanese politician who was suing over some sort of corruption allegation, and he was ordered to pay security for costs, but when he paid several £100,000 into court in cash, the defendant refused to accept that as security, and the case eventually dropped away. But I think that could play an important role. Changing the threshold on summary judgment applications. It's everything at the moment. When you're looking at a way to dispose of a case early, a SLAPP early, all the claimant has to do is keep it alive to keep the pressure on. They just got to make they've got to tell the court this is a triable issue. You need evidence which can only be properly assessed under cross-examination. Let's not let it go. That you can't kick it out at this stage, and you've got the very well-resourced legal teams, very eloquent silks. So lowering that threshold will have a massive deterrent, and I think would make a real difference. Sanctions and cost sanctions. I think the naming and shaming does have an impact. Some of these SLAPP litigants really don't care about money. Often it's not their money which they're spending on legal fees. But I think that's part of the puzzle. But yeah, I do think, I agree with you, Charlie, completely, that ultimately our judges are there to implement the law, and we do need a new law. We need a press freedom law. We need something to actually shift the paradigm. And I think anyone who's been sitting here for even part of the last 2 days feels a sense of shame about this jurisdiction and how we compare to. There certainly are worse jurisdictions in the world when you hear other stories, but we should be an example about. We've got fantastic journalists, fantastic news organisations. And it's a shame our laws, I feel, are quite retrograde at the moment. So new statute, I think, is what is ultimately going to solve this problem in the long term.
Charlie, thank you very much indeed. We've got some questions, some very interesting questions come in, and I want to ask you a question, but I'm aware of the time. So Jessica, I'm going to go straight to Jessica, because I know she's been waiting a long time to talk. So Jessica, could you introduce yourself? Thank you very much for being here, and the points that you want to make.
Sure, thanks a lot, Bob. Well, I am obviously here seated beside some very esteemed lawyers, so I'm going to try to, as a non-lawyer, I'm going to sidestep a lot of that and leave them to deal with questions and topics around that, and discuss some of the other structures and mechanisms that the government here should be using to really protect freedom of expression and media freedom with regard to SLAPPs. So firstly, some of you may have already heard the Global Media Freedom Coalition mentioned over the last 2 days. So in 2019, the UK launched the coalition, which is now made up of 49 countries, to defend media freedom where it is under threat. But as Jill Phillips of The Guardian mentioned yesterday, you can't help but feel that the government thinks that this is a problem that other countries have, or perhaps that that media freedom doesn't need protection in the UK. And I think it's fair to say that while they are one of the co-leaders of this coalition, they have repeatedly undermined media freedom, including by boycotting the Today programme and fined Good Morning Britain. They've prevented certain journalists from accessing and asking questions at press briefings. And just last week we saw that one of, I think it was the Director of Communications for Boris Johnson, issued a legal threat or made a verbal legal threat against the New European. So it's fair to say, I think, that they're not really taking their responsibility, their leadership responsibility in this regard seriously. And as Rupert said, I think, they should be leading by example on this. We've heard as well over the last few days about cross-border threats, and I think this is something that the UK could also really, or should also be leading on. Secondly, so after the coalition was launched, also they set up the National Committee for the Safety of Journalists, which has then also brought about the National Action Plan for the Safety of Journalists. I suppose, as I said, the committee had a role in drafting the National Action Plan, and the plan so far has focused very narrowly on the safety of journalists, but I think we'd really like to see it also address SLAPPs, because as we've heard, including in the previous panel, or my colleague Flatura, I think it was very, when you became emotional, I think that it's important to show that side of it, because this isn't just a legal, very clean cut, as Charlie said at the beginning, stiff upper lip issue. Like, these are issues that are really affecting people, and it was referred to as a trauma, and I think that is a safety of journalists issue if we're looking at approaching the issue of safety of journalism holistically, including mental health, which I think we should be. And so this National Action Plan for the Safety of Journalists, the government says it's a living document, and that they will revisit the plan, which was published in March, published for the first time in March earlier on this year. But we'd like to see, as the growing evidence of SLAPPs continues to emerge, and we need journalists to help us with that, right, to bring these to light, so that we can show the government that this needs to be included in their plan. Thirdly, as well, we'd like to see the UK play a bigger role at the Council of Europe. The Council of Europe platform for the protection of journalism and safety of journalists was mentioned several times over the last few days, and we do file SLAPP, media freedom alerts with regards to SLAPPs on the platform. And we'd like to see more engagement from the UK government on that as well. So this year, or just in the last year, we filed 3 alerts. I should say that that's obviously not reflective of how many SLAPPs there's been in the UK during that period. As I say, we do rely on journalists to actually notify us of those SLAPP actions, and we need to, they need to be kind of current as well for them to go on the platform. But the government has only replied to 1 of those 3. So we need more engagement. Finally, fourth and finally, as I said, this is not a problem for just out there, the rest of the world that the UK, which the UK government seems to think it is. Also in Northern Ireland, so Northern Ireland didn't act in lockstep with England and Wales when they brought in the 2013 Defamation Act. The defamation legislation that's in action there is from 1955 and 1996, so it's pretty outdated and it's in need of reform. And even though the 2013 Defamation Act it's not a silver bullet, it doesn't solve everything, it's certainly better than what is currently the situation in Northern Ireland. Basically we see as well that creates space. Maybe Rupert, you might want to speak a little bit about that as well. It creates a space for abuse of the law as well, including targeting elsewhere in the UK. So a carbon copy of the 2013 Defamation Act is currently before the Northern Ireland Assembly, and we really hope that will be taken forward in the coming months as well. And I hope maybe we can discuss some of these points as we go ahead, but I'll just leave it there for now.
Guys, thank you very much indeed. Before I come to the questions, a couple of questions that have been sent through. I just want to ask, who should I ask? Yes, Rupert, very quickly. What is the percentage of, if it's trying to stop SLAPP, what is the percentage of effectiveness of a new law versus some change in custom, and to what extent will a new law encourage a sort of cultural change within the law that means actually we shouldn't be doing SLAPPs in this country. Is that clear?
I mean, I think I get the gist. I think our law evolves in various ways, and it's often when you're involved in a court case, it's very easy to get very frustrated with the judge who's hearing your case for not seeing the bigger picture and not seeing what's really fair, sort of quote unquote. But we have a very well developed legal system with a rule of law, and if a judge doesn't apply the principles that exist or their best understanding of the law as it exists, then they're likely to be appealed, and judges don't like being appealed. They like to get the law right the first time round. So it's all very well, saying can judges move the law on and recognise SLAPPs, but the law develops slowly, and often only when you go up at appellate level, the Court of Appeal or the Supreme Court, do you really get these shifts shifts on. So that's why I think a new law is actually really needed to move stuff on.
Okay, so a question from Franz, who is with the Bureau of Investigative Journalism, and he's asking about how to achieve cultural change specifically, and he says he also points out that a lot of law firms engage repeatedly in SLAPPs, are sometimes named and shamed, and he says to them it's a bit like having a calling card. So how can we really dictate how law firms act, and how can we force that cultural change? Who wants to take that forward?
I don't mind starting on that.
Yeah.
I mentioned this very briefly when I was talking about delegitimizing the use of SLAPPs, and I was saying that this was something that we had discussed and we felt was something that really the imperative was on the Solicitors Regulatory Authority, the SRA, the Bar Standards Board, to act on. The SRA published a document called Conflicting Rights in Litigation, Balancing Conflicting Rights in Litigation. The Bar Standards Board doesn't have any similar guidance. At the moment, barristers in particular are able to hide behind principles such as the cab rank rule, and they're able to say, well, we're just fearlessly and tenaciously pursuing the interests of our client. There is this conflict there, and there is a sufficient ambiguity for them to avoid the shame that really should accompany facilitating SLAPPs. So I think at the very least there needs to be clarity there, which means that there needs to be guidance published. But I would go further, and I would say that the codes itself need to be examined in the context of SLAPPs. At the moment, and I think this has already been mentioned, if you want to hold a lawyer to account for the use of SLAPPs, you have to rely on deception, and you have to make a case largely that either they've been deceiving the court or they've been acting with a lack of integrity, and the latter, I think, is fairly underdeveloped. So I think actually building into this idea that you cannot abuse the court's processes. You cannot use it, with an improper purpose of just trying to silence speech. I think that's quite important. But I'll just say one thing really quickly. I know I'm talking too long, but that's just the very sense that this idea about the law itself changing the culture, I think that does to a limited extent, but I think it's more important that we build mechanisms into the law in order to be able to have that effect. And that can be done, as I said, through the registry of evidence.
I can see Sandhiya wants to come in just before she does. I mean, we talk about having a list of vexatious litigants. I mean, I take it there's no chance of a list of vexatious lawyers, is there?
He's a very good point.
I'm not sure Jessica would find that particularly funny, so apologies if he doesn't. Did you want to come in on that point?
Just quickly to add onto Charlie's point, it's also about hiding behind privilege and confidentiality, which is what happens a lot of the time when you get these letters. I think if you are engaging in conduct that or litigation or pre-action that is designed to shut that journalist down, and that's your only aim, or to shut public interest journalism down, you cannot, by the same account, be hiding under privacy and privilege. You should be able to publish those letters that are coming, so that people can see the attempts that are made. It's important that people know what steps are being taken to prevent this debate from moving forward in the public arena.
And just on that point, I find it appalling because I've come across some friends who've had these sort of issues, and the amount of threats and potential threats. And I'm saying this sounds like actually harassment. Why aren't you fighting back claiming harassment? Because of the amount of letters. But the problem is, because you're dealing with lawyers and people who know the law, and there is the threat not of physical destruction in this country, but financial destruction. It's almost as if it becomes, every time you get another abusive letter from some incredibly well-paid lawyer acting on somebody on behalf of a very rich person or institution, it's sort of numbing you into silence. It seems to be it is a legal form of intimidation.
I think if I could just briefly come in as well, sorry Bob, if you can hear me, just on the subject of cultural change. I think one of the big issues that we're facing as well is that people don't really understand what the role of journalists is. You know, earlier on, Matthew Carano Galizia said that people have this idea that, you know, journalists receive a tip, they write up the story, and they just press publish. And I think not only do people think like that, but they also believe that they don't really understand that journalists are there to hold power to account, and they have an essential role in democracy, and that there's you know, it's in a wider picture of rule of law as well, and democracy, human rights. They're not just there to make people's lives difficult, just to, you know, and to harass politicians or things like that and so on. And so I think we need to have maybe like an information campaign. You know, the government should obviously take a bigger role in this as well, and also maybe civil society also to make people understand the role of journalists and the importance of media freedom.
Right, Jessica, I don't know if you can hear, we've got bells in the background, so I'm going to wave goodbye. Charlie, can you take over? But I've got a question from a gentleman in Sudan who talks about how to protect this authoritarian hegemony in African countries like Sudan, and that why aren't there sanctions for countries that violate international laws? I'm not sure if that quite covers the same ground, but I'm wondering if, have you got access to that question? Can you see it?
I can't. I think maybe Susan's sent it my way there. So don't worry, I think it's going to be sent my way.
Fantastic. Okay, I better go and bang on a suit and run and vote. So very nice to see you all, and I will see you all again soon. Thank you.
Thank you very much. So I don't know if you caught the last question about Sudan. I've just got it now. I'm reading through it now. It's how to protect journalists in light of the authoritarian experiences in countries such as Sudan and restriction of journalistic freedoms. Why weren't there sanctions for countries that violate international laws and work to restrict media freedom? I don't know if anyone's got any thoughts about that.
I mean, I suppose it's a bit beyond the scope of my day-to-day experience, but we have, thanks to a lot of important campaigning, we've in the EU and the UK finally adopted the equivalent of US Magnitsky sanctions in these jurisdictions, and I think these are really powerful tools. You know, I know UK law firms who are perfectly happy to act in the UK for people who are subject to US Magnitsky sanctions, threatening journalists in the UK about matters which are tied to those sanctions, and you know, that wouldn't be possible in the US. And so I do think both in the UK, well, in the UK we wouldn't sanction people in the UK, we'd investigate and charge them, but in terms of you know, projecting higher standards around the world, once people are sanctioned by our government or the EU authorities because there's intelligence that they are corrupt, and that's the government's, you know, view on matters, those people are probably going to fall out of the SLAPP game and the, you know, abusive libel game. And I'd hope at that point the only lawyers they'd be getting in the UK are ones to you know, interact with the authorities about those sanctions, and not beyond that.
I think there was, if you don't mind me just butting in there, I mean, there was a conversation earlier about the due diligence obligations, which should be imposed on lawyers. It's something that we've explored in depth, and there's kind of two different issues here. There's the question about, and we often refer to them as SLAPP tactics. So, tactics to try, for example, to deliberately stretch out proceedings so as to cause as much pain and drive out cost as much as possible for the defendant. And then there's a separate issue about when we often refer to as facilitating SLAPPs, i.e. representing people who are transparently using the legal process as a means of harassing their critics. There's kind of two different issues there, which I think are really interesting to explore. I think the first one, the use of abusive tactics, is potentially easier to address than the second. I think really the problem with the first seems to be a lack of evidence, or being able to show that this is the real purpose. It's all too easy to be able to say, oh no, the real reason we were, delaying was because of unavoidable conflicts of schedule or whatever it is. The second one, about facilitating SLAPPs, is where things get really quite messy. Because then people say, well, that will then run up against this principle of non-discrimination, or the CAD rank rule. We can't make a decision about who it is we represent. But crucially, if there are very compelling reasons, if it's really obvious, if there is compelling evidence that the real reason they're using it is just as part of a broader campaign of harassment, there really should be accountability for that. I don't know if you've got thoughts about that.
Yeah, there's a lot to take in. I mean, also just to revert back, but I think it's important with the question from the gentleman about sanctions and to go on from what you've both said. I mean, yes, we're talking about UK, but there's a whole ecosystem that happens here. There's journalists based here that have sources in other countries as well. And if, for example, we have to get our own house in order, I think. First, we have to have the moral authority to say we take media freedom seriously, and there are lots of things that we've obviously been talking about. So that's sort of the first thing, and part of that is other countries and other journalists not viewing this as a very friendly jurisdiction, which it still is, and it has implications. It has implications for other sources that are also living in other countries as well, that are either whistleblowers or informants or part of that. Particularly when you're uncovering international human rights abuses, there's a very, very tight ecosystem. So it's incredibly important that we take these things seriously here, because they do have, we're talking about the UK, but they have wider ramifications as well than the UK.
I mean, touching on your point, Charlie, I was saying to Sophie earlier that I'm not an intellectual property lawyer, but my understanding of trademark law is if you make an unjustified trademark threat, if you threaten another business saying you're passing off or infringing my trademark, and it turns out that there isn't actually merit in that complaint, the person you threatened and you never issued a claim has legal recourse against you for the impact of that threat on their business. So it just feels like we've got something slightly wrong, where our IP laws protect the wrong of businesses being heavy-handed with other businesses, but there's no protection for lawyers writing 15 10-page letters throughout a whole weekend to get a story killed, which goes to you could argue probably a more important public good. So that's just a sort of observation, but I think it's incredibly difficult and incredibly sensitive that holding lawyers to account for who they represent, because points of privilege you've mentioned, Article 6 rights to fair trial and fair representation, but I think there are definitely firms out there overstepping the mark, and this increasing tendency of legal threats to be sent anonymously from generic law firm accounts, reputation at blank firm, I think shows an unwillingness by partners and associates to actually be associated with their own client, which perhaps telling you something. I think the in trying to move the law on, I think it is really important that we keep an eye on the unintended consequences of going too far, and recognizing that there are legitimate libel claimants, and there are people who suffer badly when their privacy is invaded or are unfairly defamed on the internet, and having a degree of recognition of the other side's perspective, and recognizing when Article 8 rights should prevail over Article 10 rights, reputation and privacy should prevail over free speech. I think that will only make, if we keep our eye on the other side's perspective, it'll only make our proposals and our arguments to move the law forward stronger.
Thanks, Rupert. I've got a comment and a question, but if anyone here does have any questions, please do raise your hand. I'm going to start with a comment which is coming online from Adelaide Lopez at Wigan LLP. It's clear that a change in law really can have an effect. See, for example, what happened when the success fee uplifts were finally removed for publishing claims. The ambulance chasers who were really taking advantage of the most vulnerable potential claimants disappeared almost overnight. And with them, those cases, which were a waste of time and money for publishers, have really reduced. I don't know if anyone's got any thoughts on that, but it's an interesting parallel.
Yeah, it's been a fantastic change, and I couldn't agree more. ATE, this is CFA uplifts and ATE policies has been lead to completely abusive costs being run up, which no client themselves would actually ever incur. Mm-hmm. And yes, just changing the cost rules has had a enormous impact and made the lives of a lot of publishers a lot easier. So I agree with that.
Room for optimism there. I've got a question here for both Sophie and Robert. Maybe I'll start with you, Sophie, which is, what is the attitude within the legal profession on this issue? Do we need more lawyers to speak out against this part of their profession?
Yes, perhaps I'm encouraged by my freelance status. I don't know about Rupert, but no, we do, and I think it's important as well. We were talking about, I think, education and culture, but even for me, when I started talking with Susan first, I had to be educated on what a SLAPP was. For me, there was a distinction between a very robust letter and somebody acting robustly for their client, and perhaps actually letters, when I thought about them, where I thought, no, actually they were threats. They were not talking about the law. As Rupert was saying, I mean, I'm not just here saying free speech and journalists and people making programs never do anything wrong. That's not what we're talking about here. But when I get a letter from another law firm, what I expect is that they're also going to engage reasonably with the issue that we've raised, or that's been raised by it, not, as I say, a chance to start telling you that they can issue injunctions which they're not actually legally able to do in any event, or, as I say, to make threatening and actually quite rude remarks about the people that are writing the stories. So I think, firstly, it is an education. I think even for me as a lawyer, it's sort of distinguishing. This is just somebody that's robustly and has a right to put their claimants' claims to you, and this is actually somebody that is issuing language and behaving in a way that's in accordance with the SLAPP.
Thanks, Sophie. I don't know if you've got anything to add to that.
Well, I agree with all that. You can tell the difference. A law firm which doesn't engage in this practice, you take them more seriously when you get a letter from them, because you know they won't write something that goes, beyond the law, that they don't engage in abusive practice, that they have some discretion about their clients. So I personally think it's in like my colleagues who are doing claimant work. I think it's in their interest to move out of the market of acting for some of the shadier clients who come this way, and advising our clients. We often, we'll take very seriously and we'll listen to people who don't overstep the mark and don't engage in this kind of abusive practice.
Interesting one here, which I guess a good follow-up from this, is whether law firms defending media consider reporting other law firms who they believe are sending vexatious threats to their clients to the SRA. Have any lawyer-on-lawyer combat going on there?
Yeah, it does happen, but we're generally quite reluctant to do that. I mean, you do get claimants reporting you to the SRA, claimant solicitors, because they're unhappy with something. But the regulator doesn't normally get involved, and it would have to be quite a serious matter, a clear breach of the rules for us to consider doing that.
Got a question here, which actually I think this leads on nicely from what we were talking about. Has there been an attempt to involve the Law Society as the profession's regulatory body? And a separate question about how receptive have UK parliamentarians been, and is there a parliamentary committee set up or planned? I think we'll probably separate those in two bits. With the profession's regulatory body, I don't know if anyone's got any thoughts about that.
I mean, I think, as probably has been said, it is quite a high bar, and again, it's part of this education. I mean, it is sort of really difficult. I mean, one thing I always think about, and I always think to myself, am I being too highly principled? But when I was first started out studying, one of the things that you were taught, particularly at the bar, was that if you were dealing with people that were unrepresented, then you had to take that into account and not use it to have a barrel over people. And sometimes I see this manifested in some of the correspondence that gets sent to journalists or producers when they're acting on their own, and then when those same sort of letters are possibly sent knowing that they're dealing with a lawyer. It shouldn't really be that discrepancy. And I think, I'm pretty sure, I mean, I'm scratching my head because it's a few years ago now, but I'm pretty sure that was, as part of your ethics, that was one of the things that was sort of drawn into you, that at the end of the day, you're an officer of the court. Yes, we all act for our clients, but what we're really there to do is to uphold the law. And not just run away with the money that we're paid and forget all of that.
Yeah, I mean, I completely agree. There was, and I think there still is, in the new SRA regulatory code, an obligation not to take unfair advantage.
Mm-hmm. Is there?
And yeah, I mean, we in the last year or 13 months, I've had done 3 jurisdiction cases against an Italian news organisation, a Swedish news organisation, Realtid, which was mentioned earlier in the conference, and just last week a Spanish news organisation. Without picking out any particular case, issues we've had is writing letters of claim which don't comply with the pre-action protocol, which don't fairly describe the rules and jurisdiction, and suggest it's a sort of no-brainer that the courts here would accept jurisdiction. They don't even write to them in their own language and expect them, and then blame them for not engaging in not responding. So yeah, I think I've never heard of SRA taking issue with it, but I do think there is a temptation when you're in the territory as a reputation manager of sending out notice and takedown letters, cease and desists. You're firing them out to websites around the world. I think there is a temptation to forget your position as a solicitor, forget your obligation not to take unfair advantage of the recipient's lack of knowledge. It may be a big media organisation, but you can't assume that the foreign media around the world knows the intricacies of English libel and jurisdiction law.
I just add to this because I think it's a really good question. I'd say first of all that it's very much on the to-do list of the UK working group to engage Law Society, but it's part of a broader effort to raise awareness and to delegitimise the use of SLAPPs, to reach out to lawyers. There does need to be more education about this, and also, like I said, providing clarity about how to reconcile some of the more complex ethical principles with the use of SLAPPs, I think is really important. Something that Annika said in one of the previous sessions I think is worth re-emphasizing again, because she mentioned about law students and about this movement that you've got in some parts of the USA in relation to fossil fuel, law firms that are facilitating some of the abuse of fossil fuel companies. I think it'd be great to see something like that in law schools. This is something I've had a conversation about yesterday. It's something you see in the USA and here, which is that while there is a course on legal ethics, while that is you have to pass your ethics exam in order to be able to get your to be able to pass the bar, there isn't really a live discussion when it comes to selecting which law firm you go to about the ethical standards that they have. And I think that's something we need to have more of a presence on in law schools, which is like that needs to really, we need to get to a point when that is really factored in as one of the considerations as to which law school a student joins. I've got, maybe I could just pursue the second part of the question I raised before, which is how receptive UK parliamentarians have been and about parliamentary committees. Jessica, maybe I could direct that one at you about the parliamentary landscape in this respect.
Yeah, so we've had a few meetings with parliamentarians, including Bob Seeley, and it's something that we continue, that we're going to continue to try to do as part of the UK working group as well, because, as Sophie said as well, it is about educating them also, as legislators about why this is important and why it's important for them to take action in this regard. So yeah, it's part of an ongoing process. Some are more receptive than others, let's say, but we're keen to bring more of them on side, especially now, as has been mentioned, that the EU is taking action against SLAPPs. Hopefully that will, help, I suppose, raise awareness about it and of the importance as well of taking action in this regard.
Thanks, Jessica. Yeah, I think again ties in with this question about raising awareness and how important that is. So I think after this session, you go away, you contribute to the consultation, you read our proposal, and then you start tweeting about SLAPPs. It's going to be important on everyone's to-do list. I've got another question here, which is about, is there a way to tie this into high levels of noise around environmental, social, and governance investing? It says non-ESG compliant businesses are now starting to suffer in terms of their access to capital, which would surely irritate any wealthy individual. Is it possible to have this become a part of ESG investing criteria so it's tracked and pressure is put on the investing community? That is a great question. I've got some thoughts, but maybe Sophie, you wanted to come in first.
Yeah, I mean, I'm really interested in this space of business and human rights, and I think it's, and as we see in the whole sustainability ESG sort of sector, companies, corporations, everyone's being measured on environmental goals, things like modern slavery, but what about you're facilitating or inhibiting, or your parts that you're playing when it comes to issues of SLAPPs or free expressions or access to information? And I think that's a really, really important space. And it's sort of related, but I mean, particularly I've worked in obviously bigger kind of organisations, but also now in my capacity, I'm, advising very independent companies that have only just one or two people where the resource is few. And I think if you are a company that has a lot of resource, I think you have that bigger responsibility to ensure what you're doing and what the impact is on free expression. I do think personally the sort of business and human rights space and ESG is a really good and kind of innovative way of looking at this as well, and we should definitely be incorporating it in our thinking.
You go ahead.
Well, the only thing I'd jump in on that is as soon as you have some body that is deciding that X company or X person is abuses the court process and issues SLAPPs, that they'll be the next, that body will be the next defendant. Just like bodies that do AML processes that assess, that play any role in trying to outside of the court process and court convictions. Whenever anyone raises suspicions or concerns and records that, that's processing personal data. They're a data controller, and the claimants' letters will just start hitting those investment platforms that share this information or refuse to, inaccurately describe them as abusing court processes. And so, the sort of cycle continues. Yeah,
that's why you need a solidarity network, I suppose. I just add one thing. I'm not sure whether, Jessica, you want to come, but I'll just say one thing really, which made me think of this. I think just being able to characterize this as human rights abuse is an important thing to do. A lot of people don't think of it in human rights because they think of attacks on human rights as always emanating from state bodies, from government bodies. And they don't realize that corporations or powerful individuals can impact human rights in the same way, or can exercise powers of censorship in a way which is comparable to government bodies. So that's important in itself. The other thing I would just raise awareness to is that this is something, the engaging investors is something that has already been undertaken elsewhere in the world. The Business and Human Rights Resource Centre, we heard from Lady in the first session, have been very good on this one. They put together an investor brief, which you can find online, which lays out, again, the implications of SLAPPs for human rights and talks about the obligations of investors. I think there was some success, I think it was earlier this year, I've got it in front of me here, for an investor statement on SLAPPs, where 44 institutions with more than $270 billion of combined assets called on companies to take broad systemic action to protect human rights and ensure they do not use or support SLAPPs. So again, there has been that success on the global stage, and I think it'd be great to apply that on a national level and ensure it actually has some practical effect. We're getting too close to the end. I don't know whether, Jessica, you wanted to come in with any of that.
Well, I could say, that I heard recently someone mentioned that I think it was of the tech companies, the people who were whistleblowers in the tech companies are identifying themselves increasingly, I think, as dissidents, as if these really large corporations are countries, and I think that this is something that is really ties into something that came up in the first panel as well, which is around inequality and the rise, the fact that there's more and more millionaires, more and more billionaires, this means that there needs to be a rebalancing of the a key symptom of a SLAPP is the inequality of arms. So there needs to be a rebalancing done there to take to kind of counter this rich get richer phenomenon, I suppose.
Absolutely. I think it's really good to remember the broader systemic problems of which this is a symptom that we need to address as well. I think that's a good note to wrap up on, unless anybody's got any final questions. I'm going to wrap up now, mainly because I do want to do one final plug, and also because we're fortunate enough to be able to hear from Maria, who's the Director of Justice for Journalists Foundation, who's going to wrap up this conference. Before we do, I would like to say one thing. I said it briefly at the end of my presentation, but I would like to emphasize it again, which is that we're going to be opening up this, and for anyone who's in the room, you can actually see our proposals. I've got a physical document here that you can read through and you can take away with it. It's not quite as good as the gift I got from Claire yesterday, but it's it's all right. I'll give it to you if you like. And you can find that online. There is a consultation document, a Google form that you can access and you can contribute. If you've got any thoughts at all, we would appreciate to hear from you. You can find this on the conference website. I don't know if we've got an address. Thank you so much. anti-SLAPP-conference.info. And there is a resources part of that website, and you can find there this proposal, and you can find the link to the consultation. With that, I think we're a little bit early. We've got a couple of minutes early, but I think we will wrap up at this point so that we can give time to hear from Maria. Oh, he's here. Thank you so much, Maria.
Thank you so much, Charlie, and it's really hard to speak after this brilliant panel. So I'll try to be brief, but I really wanted to start with thanks and continue with just a few finalizing wrap-up comments. So starting with thanks, I really would like to thank our host, which is Open Russia, and amazing technical team who is headed by Anthony and who made this all happen and run so seamlessly. So thank you very much, Anthony. We can't see you, but we know you're here. Thank you. And of course, our co-organizer, which is Foreign Policy Center, with Susan and Poppy and Adam. Thank you, guys. It's amazing, and I'm very privileged to be able to work with you for the last, I think, 15 years. And yeah, I think it's in different capacities and my different roles. But this is another amazing example of how great is the work that you're doing. And of course, I would like to thank my team, who were instrumental in putting this all together and working on the website, and Vafa, who is not here, Vafa Fatizadeh, whom you know from the anti-SLAPP coalition. She represents us in the working group, represents Justice for Journalists Foundation, and she was instrumental, and the other guys from my team here as well. So thank you very much. And it's also Vafa's birthday today, so it's a good present to her, I think, the success of this conference. And of course, I would like to salute to all the amazing chairs and speakers and the audience. It's an incredible honor to have been in the same room with all these brave journalists who stand up to intimidation and quasi-legal bullying. I extend my admiration to strategic thinking NGO representatives, researchers and politicians who clearly recognize this severity of what used to be perceived as a very niche problem. I thank you for tirelessly looking for ways to expose this criminal practice and fight corrupt and disproportionate pressure tactics employed by powerful and wealthy against the truth that threatens their existence. And there are a couple of points or concepts that I would like to highlight in my closing remarks, and they've been all highlighted in this conference. So first is really the expression which seem to have been mentioned in every remark we've been listening to, which is a chilling effect. And this, I think, certainly deserves special attention as because of the frequency, obviously, and because the striking similarity of this impact, which is demoralizing, extremely demoralizing impact of those exhausting tactics with usually zero legal merit, that are aimed solely at draining the journalists' resources, which are moral, emotional, financial, reputational, physical. And coming myself from a very chilly country in many senses, that has seen only really a couple of decades of thaws over the last 100 years. These 100 years were, of course, very politically and socially freezing. So I can testify to the destructive impact on the generation of people that this chilling effect has. And of course, those who speak up in these conditions, those who are keen to discover and publicize the truth, and who project democratic values, are usually squeezed from countries like that. They are deprived of their freedom, and they sometimes are almost driven to take their own lives as the only remaining means to express their protest against this gripping political winter. I'm very hopeful that examples of actions of this aggressive and accountable kleptocracies mentioned here today, like Russia and Kazakhstan, as well as those that that were not mentioned today and yesterday, like Belarus, Turkmenistan, and China, and the actors, of course, who employ the same aggressive tactics against journalists, so-called legal methods. And they take these tactics to extreme. I do believe that this will serve like a wake-up call to the rest of the world. And naming those countries and actors well known for oppressing their own citizens, take me to the second concept I would like to highlight today, and this concept is weaponized bullying. We all know that it takes a lot to stand up to bullying. And weaponized and well-funded bullying, masked as the legal or legitimate legal tactics by seemingly respectable members of the society, legal professionals, is almost impossible to stand up to. And it is true that no one can resist standing. No one can resist these tactics standing up alone to them. And this brings me to an important point, that this conference is specifically serving this purpose of showing that no one has to do it alone anymore. And although, of course, there is a gaping inequality of the playing field that, again, was mentioned many times today, and the lawfare is supported by seemingly unlimited funds, there is a growing recognition of this phenomenon, and the body of support is being formed and is being strengthened as we speak. And this conference, I believe, clearly contributed to the growing awareness of what is really hiding behind the smoke screen of legalistic language of fancily letter-headed letters. SLAPPs against journalists or lawfare or quasi-legal bullying should stop. As this incredible collection of talent that we had the privilege to listen today and yesterday has vividly demonstrated, we do have a capacity to stop it. Which brings me to the third concept that was implied yesterday and was actually explicitly pronounced today, which is solidarity, of course. Although journalism used to be viewed as highly competitive industry, we now see more and more cooperation between journalists from different countries working to uncover transnational crimes. It is my strong belief that such cooperation within the industry must be taken further. I believe that it is ultimately the enhanced solidarity within this industry and beyond that will save journalists from aggressive and destructive might of hybrid attacks, of which SLAPPs are an integral part. And we purposely brought speakers from all over the world today and tomorrow. And it was indeed heartwarming to listen to the mutual expressions of solidarity and awe about the similarities of experiences by journalists from South Africa, Australia, USA, Europe, and the UK. Actually, probably say it again. The thing that Rebecca mentioned from this stage today, and something that I heard throughout the conference on the fringes, it was indeed, this conference indeed served as a sort of a Me Too moment that actually highlighted that everyone shouldn't suffer alone. The experiences are shared, and in solidarity, those experienced can be remedied. So I'm optimistic about this solidarity and about the momentum that this conference built, and I'm optimistic about the targeted counter-SLAPP measures that were being discussed over the last 2 days, and they include, of course, publicity, trial monitoring, due diligence, legal, psychological, financial help to the targets of vexatious legal threats, and many other measures. If argued for and promoted and implemented systematically, those measures will ultimately lead to a more favorable environment for exposing the wrongdoings, strengthening media support, and ultimately a genuine and not declarative democracy. And as Dario Milo said this morning, he quoted an famous African proverb that it takes a village to raise a child, and he said that he's proud to be this part of the village that is going to ultimately bring the SLAPPs to the end. I think we are seeing the beginning of it, and I think we all, as this village, are going to bring this collective case ultimately to the winning dimension. So thank you very much again for participating, and I hope we meet again soon. Thank you.